Dear students, in the previous lecture, I have discussed the UN Security Council's role and the challenges which it faces while discharging its role, its functions. Today, in this lecture, I am going to discuss the brief history, purpose, and composition of the International Court of Justice, also known as the World Court. This International Court of Justice is the principal judicial organ of the United Nations. The UN Charter itself, in its Article 92, says that International Court of Justice shall be the principal judicial organ of the UN. Established in 1945, it plays a crucial role in settling disputes between states and providing advisory opinions on international legal issues. Dear students, the idea of a world court has been very old, and people in all countries have supported this idea. It was greatly felt by the politicians, masses, and various national and international organizations that international disputes should be settled peacefully and amicably. It was in 1899 that Permanent Court of Arbitration was set up. Then, under the League of Nations, the Permanent Court of International Justice was set up. With the establishment of United Nations in 1945, the International Court of Justice was created as the successor to the Permanent Court of International Justice. Thus, International Court of Justice was born from the ashes of World War II with the aim of creating a more peaceful and just world order. It succeeded the Permanent Court of International Justice, which had been established after World War I but was unable to prevent the outbreak of the Second World War. The International Court of Justice location in the Peace Palace in Hague symbolizes its commitment to peace and its role in resolving disputes peacefully. In other words, the International Court of Justice, which also known as the World Court, stands as a symbol of justice and peace in the international arena. So, International Court of Justice wasn't entirely a new creation, rather it was built upon the foundation laid by its predecessor. The Permanent Court of International Justice, which failed to prevent the outbreak of Second World War, the ICJ, taking these lessons into account, aimed to be more influential in maintaining global peace. Now, what is the purpose of International Court of Justice? Dear students, there are multiple purposes of the International Court of Justice. The primary purpose of International Court of Justice is to provide a peaceful means for the resolution of disputes between states. It also contributes to the codification, interpretation, and application of international law. It also promotes rule of law. The International Court of Justice also provides advisory opinions on legal questions referred to it by UN organs and specialized agencies. Through its role in resolving disputes and providing legal clarity, the International Court of Justice contributes to the maintenance of international peace and security. By offering a peaceful mechanism for the resolution of conflicts, the International Court of Justice also helps to prevent tensions from escalating into large scale conflicts. Its proceedings also offer opportunities for states to engage in constructive dialogue, negotiate settlements, and build mutually beneficial relationships. So, in short, we can say that the purpose of the International Court of Justice is to promote the peaceful settlement of disputes between states, uphold the rule of law in international relations, and contribute to the maintenance of international peace and security through the application and development of international law. Dear students, now let's have a look at the composition of the International Court of Justice. The composition of the International Court of Justice is established through the provisions outlined in its statute, which governs its structure and operations. According to Article 2 of the ICJ statute, all members of the United Nations are de facto members of the court. It means that any country that is a member of the UN is also a member of the International Court of Justice by default. Now, what about non-member states of the UN? The statute of the International Court of Justice says a state which is not a member of the United Nations can still become a party to the statute of the International Court of Justice, but under certain conditions. These conditions include acceptance of the statute and other obligations with respect to the court. Second condition is agreeing to contribute to the expenses of the court, therefore supporting its operations financially. So, dear students, Article 2 of the ICJ statute outlines the composition of the court. Originally, it stipulated that there would be 15 judges in the ICJ. These judges are elected irrespective of their nationality, ensuring a diverse representation in the court. The criteria for selection is that the judges must be individuals of high moral character and possess the qualifications required in their respective countries for appointment to higher judicial offices. Additionally, they should be jurists of recognized competence in international law, reflecting the specialized nature of the court's jurisdiction. However, it is worth mentioning that the original number of 15 judges in the ICJ has been increased to 16. So we can say, according to the ICJ statute, judges must possess high moral character and the qualifications required for appointment to the highest judicial offices in their respective countries. They should also be recognized experts in international law, which is crucial for interpreting and applying the law in the cases brought before the ICJ. Secondly, while membership in the UN automatically includes membership in the court, non-UN member states can also join under certain conditions. In addition to that, The number of judges has also been increased from the original number of 15 to 16. Now, how judges of the ICJs are elected? The election of judges for the ICJ follows a specific procedure outlined in the statute of the court. This process begins with member states of the United Nations nominating candidates for the position of judges in the ICJ. Each member state can nominate individuals who it believes are qualified and suitable to serve as judges in the court. Once candidates has been nominated, these candidates submit their candidatures to the UN Secretary General. The candidature includes information about the candidate's qualifications, experience, and expertise in international law. The candidature of these aspiring judges are then reviewed by both the UN Security Council and the UN General Assembly. The Security Council assesses the qualifications and suitability of the candidates, and even it can hold informal discussions or conduct interviews of the candidates to gather more information. However, it is important to remember that the Security Council does not have veto power over the election of judges. After the review, then General Assembly and the Security Council hold separate elections to choose the judges. In these elections, each member state of the UN have a vote. The candidates who receives an absolute majority of votes in both the General Assembly and the Security Council is elected as judges of the ICJ. So, in simple terms, the election of judges for the ICJ involves a thorough process of nomination, review, and election by the UN General Assembly and Security Council. The aim of this rigorous process is to select individuals who are highly qualified, impartial, and capable of upholding the principles of justice and international law. What is the tenure of judges of ICJ? The tenure of judges in the ICJ refers to the duration for which a judge serves in the court. Judges of the ICJ are elected for a term of 9 years. This means that once elected, judges serve in the court for a period of 9 years before their term expires. This 9-year term has been fixed for the judges to ensure stability and continuity within the court. To maintain continuity within the court, the term of ICJ judges are staggered. Staggered term means that not all judges in the International Court of Justice start and finish their job at the same time. Rather, they have different start and end dates for their service. This means that not all judges are elected or re-elected at the same time. Instead, the terms are structured so that approximately 1/3 of the judges are up for re-election every year. Judges of the ICJ are also eligible for re election. This means that at the end of their 9-year term, they can stand for re election if they choose to do so and if they meet the necessary qualifications and criteria, then they can be re elected as judges. The statutory terms and eligibility for re-election ensure a rotation of judges in the ICJ. This rotation helps to maintain a balance between experienced judges and new appointees, ensuring that the court benefits from both continuity and fresh perspectives. Dear students, there is no specific retirement age for the judges of the ICJ. Unlike some national judicial systems, where judges are required to retire after reaching at a certain age, ICJ judges can continue to serve until the end of their term or until they choose to step down. The tenure of judges in the ICJ is designed to uphold principles of impartiality and independence. By serving fixed terms and being subject to regular elections, judges are expected to remain impartial and independent in their decision making, free from outside influence or pressure. So, in conclusion, we can say that the tenure of judges in the ICJ is fixed for 9 years. There are staggered elections. They are also eligible for re-elections, so they could act impartially and independently. These principles are fundamental to the court's ability to fulfill its mandate of administering justice in accordance with international law. Another part of the composition of the ICJ is seat of the court. The seat of the International Court of Justice refers to the location where the court conducts its official business and holds its sessions. The International Court of Justice has a permanent seat which is located in The Hague, Netherlands. The Hague is a city known for its international legal institutions and is often referred to as the legal capital of the world. The choice of the Hague as the seat of the ICJ reflects the city's historical significance in international law and its status as a center for legal diplomacy. In Hague, the ICJ is housed within the Peace Palace. This building is a symbol of peace and justice. The Peace Palace was constructed in the early 20th century by Andrew Carnegie, an American philanthropist who dedicated it for promoting peace. So, it was intended to be a venue for the peaceful resolution of international disputes, making it a fit location for ICJ. So, the seat of ICJ is located in The Hague, Netherlands, within the Peace Palace. This historic building serves as a symbol of peace and justice and provides the court with the facilities needed to carry out its mandate of resolving legal disputes between states in accordance with international law. Dear students, there is a presiding officer in the International Court of Justice. The presiding officer of the International Court of Justice is the president. This president of the ICJ serves as the leader, as the spokesperson of the court. He presides over the meetings and sessions of the court, ensuring that proceedings are conducted smoothly and efficiently. The President also represents the ICJ in its external relations with other international organizations and governments. The President of ICJ is elected by their fellow judges from among the members of the court. He is elected for a term of 3 years, although the President can be re elected for additional terms. The election process ensures that the president is chosen from among the most experienced and respected judges in the court. The president of ICJ has several responsibilities. He oversees the administration of the court and its staff, ensuring that resources are allocated effectively and that the court's operations run smoothly. The president also plays a key role in setting the agenda for the court's work, determining which cases will be heard and when they will be scheduled for hearing. As the official representative of the ICJ, the President represents the court in its interactions with other international bodies such as the United Nations General Assembly and Security Council. The President of the ICJ is expected to uphold the principles of neutrality and impartiality in his role. He must act objectively and independently without favoritism, without bias towards any particular country, any party. This ensures that the decisions and rulings of the court are made based on the merit of the case and in accordance with international law. Thus, the president of the ICJ plays a key role in leading and representing the court, ensuring that it fulfills its mandate of resolving legal disputes between states in a fair and impartial manner. Now, how decisions are taken in the ICJ? Dear students, the court takes all decisions by majority of judges present. In case of tie, the president of the court has the right of casting vote. To make decisions, the court employs various methods ensuring fairness, thoroughness, and adherence to legal principles. Adjudication is the primary method of decision making in the ICJ. This involves the court is hearing legal disputes brought before it by states and issuing judgments based on the evidence presented and principles of international law. The ICJ considers arguments from both parties, reviews relevant treaties, international conventions, customary law, and legal precedents before reaching a decision. Consent also plays a crucial role in the ICJ's jurisdiction. The court can only hear cases if both parties involved consent to its jurisdiction. This means that states must agree to submit their disputes to the ICJ voluntarily. Without the consent of all parties, the ICJ cannot adjudicate a case. One of the key functions of the ICJ is to provide authoritative interpretations of treaties and principles of international law. States often seek the ICJ's guidance on the interpretation of treaties or application of international law to specific situations. The court's decisions in such cases help to clarify the legal obligations of states and contribute to the development and consistency of international law. The ICJ also provides advisory opinions on legal questions referred to it by international organizations such as UN General Assembly, UN Security Council. While not strictly binding, the ICJ often considers its previous judgments and advisory opinions when making decisions in subsequent cases. This practice also helps us ensure consistency and coherence in the court's jurisprudence, as well as predictability in its decision making process. However, the ICJ may depart from its previous decisions. So, dear students, we can say that ICJ employs a combination of adjudication, consent, interpretation of treaties and international law, advisory opinions, and consideration of judicial precedents to make decisions. These methods ensure that the court's decisions are grounded in legal principles, fair procedures, and the mutual consent of the parties involved, thus contributing to the peaceful settlement of international disputes and the advancement of the rule of law. Dear students, in today's lesson, we have seen that the International Court of Justice, also known as the World Court, was born from the ashes of the World War II with the aim to settle disputes between states peacefully, amicably, uphold international law, and maintain global peace and security. Its composition, methods of decision making, and the role of the president are designed to ensure fairness, impartiality, and adherence to legal principles. Through its work, the ICJ strives to create a more just and peaceful world order where conflicts are resolved through dialogue, through negotiation. Dear students, in the next lecture, I will explain the jurisdiction of the International Court of Justice and its role. Thank you.